Welcome to this year's 2025 Case Law Update here at LOMAD. I'm Brendan Shannon. I'm joined by partner James Cousins.
Good afternoon.
Good afternoon.
So we've done what we do every year here at LOMAD. Throughout the course of the year, we have carefully and assiduously reviewed all of the Appellate Division cases that come down every Thursday. We review those decisions pretty carefully, we assess them, and we use them. One of the things that I'm most proud of about our practice is that we use decisions hot off the presses. They usually get a citation within a couple of days of being published. It's very rare that they don't.
Correct, and that's the fun part, is when you show up at a hearing with a binding precedent from the third department that no one else has read.
Yeah, or is even aware of usually. And so towards the end of the year, we start collecting everything together and putting together this presentation, as well as a document that we will be providing to everyone at request in PDF searchable indexed format. It will probably be finished next week.
Yeah.
But I mean, just that you're aware, I mean, this is the stack of decisional law that we just decided to discuss today. So there's a lot of work that goes into this, and I want to, before we start talking about the cases, I want to thank everyone that's been involved in helping us assemble everything, check for our typos,
right.
And help us put together what we hope will be a good and informative presentation. And just as a reminder to everyone, today's presentation does not constitute legal advice. It's for educational purposes only. If you want really great legal advice, though, you know where to go. It's come to LOMAD. So without further ado, I guess we'll get started. Let's show us our first case today. Oh, well, we'll start with our stats. This is a surprising trend, but not unexpected. The third department has kind of gone off the rails. The board has maybe gone off the rails. We've heard some comments. We actually heard a comment from a judge not too long ago saying that they were aware that the ARD has been issuing crazy decisions based on all the new lawyers they hired. That was odd to hear from a judge. But the third department has issued some sort of crazy rulings recently because they've decided that they really believe they understand the statute, which is funny because
It's about 50-50.
It's about 50-50, but this number is up. When I first started doing this over a decade ago, this number was close to 10%.
Wow.
So it was very rare to get a reversal at the board. And dismissals have become more common too, and we're going to talk about that a little bit later because we have some theories about how to address some of these weird decisions we get from the board, or whether or not things should be even appealed in the first place.
And I think this is a trend too, because last year we saw a lot more reversals.
The number is going up.
Yeah.
The number is going up. So we're going to start in what you might think is a really dry topic, appellate practice. But I picked this case because I knew it was going to make me really angry, and you guys are going to get a lot of the color out of this. Don't bother reading the slide. Just bear with me for a second. Everyone remembers the Green case that was the sky falling several years ago, where the third department decided that it thought it knew the statute better than all of us who had been practicing with it, and said, if you died for reasons unrelated to your workers' compensation claim, yet you had been previously classified with a non-scheduled disability, that is to say, a cap had been established and you were receiving active cap payments, the unpaid balance of the cap was nevertheless payable to your estate.
Right.
That the benefit didn't die with you, that it survived you. And for a very short period of time, judges were making decisions, and they did in the Coyle case, which directed the payment of the remaining cap balance to the claimant's estate. But we then know that the Court of Appeals stepped in and fixed everything. And they said, where are you coming from? What is wrong with you? It did take 2 years for that decision to get issued, but by 2022, the ship had been righted, the Appellate Division had been chastised, and we got back to normalcy. What happened in the Coyle case is the Coyle case fell into that 2-year gap where a decision was rendered consistent with the Appellate Division ruling in Green, which made the payment of benefits payable to the claimant's or the claimant's estate. In this case, it would have been the decedent, but it wasn't a death claim, so it was still the claimant. No appeal was taken from that decision because it was made pursuant to third department precedent, which was binding on all parties. So when the Court of Appeals came back and corrected everything, this carrier decided to have to issue an RB89 or an RB89 which requested rehearing, asking in the interest of justice that the previous ruling in the case, which awarded benefits to the estate, be reversed in the interest of justice. Because you know what? Based on the Court of Appeals ruling, the board has no statutory authority to direct the payment of benefits to the estate. But what happened here? The board denied the request for rehearing, saying that they should have filed an appeal at the time, and somehow they didn't. Because they didn't, that made their analysis different, which literally has nothing to do with whether the interests of justice are served here. Because you know what? The interests of justice would be served by granting the application for rehearing, by rescinding the decision which directed the payment of benefits to the estate, and closing the case again.
Right. And what the board, and they're saying here is basically you should have filed a frivolous appeal.
Because at the time it would have been a frivolous appeal.
Right.
And that's probably why it wasn't appealed. I actually spoke to the firm that was defending this case and strongly encouraged them to take this to the take this to the Court of Appeals, because I think this is absolutely absurd. How can the interest of justice, even on an abuse of discretion standard, not be served by correcting a legally defective ruling, and defective in the sense that it has no binding principle of law supporting it?
Right.
It's absolutely ridiculous. I'm kind of at a loss. I would like to swear a lot about that. It's silly. It's ridiculous. As one of my favorite cartoons once said, it's the best kind of correct, technically correct. Yeah, you technically can prevent the court from reaching the merits of the issue, but by doing so, are you miscarrying justice? Absolutely.
100%.
100%. Let's move on and see how ridiculous this gets. We picked this next case because we wanted to show you, or at least illustrate to you, what kind of world we live in. This is also about retroactivity. This is almost the same kind of legal circumstance. This claimant had a case with mixed sites, schedule and non-schedule, and the case was put to bed on a 75% LWEC at a time before Arias and Tahar became binding precedent. And as a result, the claim got put to bed on a non-schedule, or on a non-schedule PPD that was no payments due to the claimant. The claimant then sought to reopen the case later on a theory that because Tahar and Arias had been issued in the interim, she could go back and claim her schedule, which had never been paid. It had never been formally awarded and paid. The board, to their credit, did try to prevent this reopening by saying at the time of permanency, there was no evidence of a schedule in the file, and therefore they were not going to revisit the issue of permanency in this claimant's case. The third department gets a hold of this and says, oh no, we disagree. Arias and Tahar say what the statute says, and we're okay with you going back. Oh, and by the way, a subject number which you issued, board, said that if you asked for a hearing on this issue, we'd grant it in these circumstances. Now, what's the difference between these two cases? The third department got spanked in green and was affirmed in Arias and Tahar. Well, it was never really made it to the third department, or to the Court of Appeals. So their law in Arias and Tahar was affirmed. So this is basically the third department saying, well, we liked the result in green, so we don't believe it's in the interest of justice to make you not have to pay money to somebody who has no legal entitlement to it. But we like our decision in Arias and Tahar.
You know what's funny with this one too is they sort of couched their decision in the subject number that said that these type of claims could be reopened, and then later on we have a case where they expressly say we don't care about subject numbers.
Subject numbers don't mean anything. We don't give a damn. So. All right, that's funny. So all right, let's move on, because if we're going to end up sitting here for too long with me complaining.
So Sanders is a fairly quick one, but it illustrates something that we talk about a lot here at LOMAD, which is make claimant produce records. Make them produce what they're supposed to produce. Because a lot of times you'll find like it's very rare that a claimant will produce missing initial records or prior treatment records that won't help your case. They'll almost always help your case. So here, there's a pro se claimant who filed for reconsideration, but then tried to argue that the reason she needed reconsideration was because there was newly discovered evidence. However, the newly discovered evidence was simply initial medical records that weren't initially produced. So essentially what the court held is that that's not new evidence, that's just evidence you failed to produce.
Right, and this is one of the funny cases because there's an indication of what's going on in this file when they make reference to the former attorney, which means that this was a difficult claimant who fired their counsel over what happened in their case and then proceeded pro se on these appeals.
Right.
Let's move on to CESA. CESA is a case that we wanted to talk about because it's come up regularly in the last couple of years, and it's always an issue that has, I think, been problematic for attorneys in giving good advice to their counsel, which is whether some decision is appealable or not. If you sat through one of my training courses, you'd know that if you go through all the decisional law, you'll find that there is no rhyme or reason as to what the board will tell you is interlocutory.
Basically, no PFME.
PFME
is the only thing you
won't.
Well,
the only reason that that's the case is because 312 NYCR 300.38 expressly says that a finding of prima facie medical evidence is an interlocutory ruling. But otherwise, if you read board decisions, what you'll end up doing, if you think about it, is read hundreds of decisions that could have been deemed interlocutory, but weren't. They reached the merits and ruled on the case.
Right.
The Appellate Division has struggled with that concept because the board has a completely different theory of it because it needs to have one. There are very few rulings that couldn't be characterized as non-final.
Right.
That come out of a comp claim.
Right.
Yeah. So what the board did last year and the year before is they came up with a theory of aggrievement. Well, it's not a theory. I mean, they didn't come up with it. It's been around. But they started to invoke the theory of aggrievement in workers' compensation decisions, and that's what we wanted to talk about and what CESA really indicates. This is an appeal from a ruling where a judge and the board agree to hold in abeyance certain awards because there was a valid claim of voluntary withdrawal from the labor market. As a result, the claimant files an appeal. The board panel and the third department say, this is not an appeal we're going to entertain because no negative ruling was made.
It was held in abeyance.
We simply held those awards in abeyance. You're not aggrieved. So we would encourage all of you out there, and we encourage attorneys at our office when they're thinking about an appeal, is the first question you have to ask yourself is, are we truly aggrieved by this ruling? And what relief would we be asking for? I think the theory was that the claimant thought that the awards should have been continued during the pendency of the appeal, but that still isn't the same as whether they were aggrieved or not by the holding in abeyance. There was no final ruling there. That is true. But when the courts and the board seem to struggle reconciling their definition of interlocutory, the board has one that is sort of inchoate. The Appellate Division has one that's really well settled, but doesn't really apply to comp. It doesn't apply well to comp.
I can think of a lot of scenarios where something's held in abeyance and we are aggrieved. Sometimes you might take the position that maybe benefits need to be suspended immediately based on the evidence, and a judge will hold in abeyance. What are you going to do there? I would think appeal, because you actually are now paying benefits for a period where there's no basis for it.
Right. So you would be aggrieved, right?
Exactly. You could then argue that regardless of whether it's interlocutory or not, we were aggrieved.
Yeah, we have a problem. All right, let's move on. Sutphin is our funny case that Brendan made reference to earlier, where the Appellate Division says subject numbers. What do you mean silly subject numbers? A subject number was issued about 4 years ago that provided much needed and helpful clarification on how law firms and parties should fill out and file appellate papers in cases that are traveling. Right. And they might be traveling on various issues, causal relationship, new accident versus aggravation, or apportionment, or whatever. There are two or more claims where there are potentially two or more parties who are interested, who are potentially liable based on the results. And the subject number is 0461106R, which is funny. It's like when you have to put like that last letter, the R. Okay. That one tells us that you basically take the identical appeals, make duplicates of them, but both appeal cover sheets should have the data for all of the claims that could potentially be interested. And for each copy, you circle the relevant data set for the claim in which it's being filed, and that should route it. This was essentially a way to fix Xerox's screw-ups when you would file appeals, and they would take 5 copies of the same appeal and put it into one file instead of filing one in each of the 5 cases. In this case, the the carrier did not follow the subject number. And this is Liberty, if you remember a couple of years ago, there was a really terrible series of decisions about multiple failures on one of Liberty's appeals that ultimately ended up leading to a death claim being established, but against them when they weren't even the liable carrier. But in any event, they didn't follow that guidance, and the board rejected the appeal. Here we have the board saving their bacon for them, or the appellate division saving their bacon and saying, your subject number doesn't mean anything. They did file it. There's some indication that perhaps this was also a routing error on the part of the board or the board's scanning vendor. But in any event, it's funny because we just told you about a decision where the appellate division, if not hinges, rests one of its four corners of its argument on a subject number, and here says no. And I think the board's denial of the appeal was entirely proper based on what the subject number says.
Right.
The short of this is, if there's a subject number, try and follow it. It saves you heartache. Then you don't have to go to the appellate division and cross your fingers hoping that they're going to have a wild hair and ignore a subject number.
Right. What saved them here, though, is that the rule is that basically you can only deny an appeal based on something not followed in the regulations or not followed on the instructions.
It's potentially a 23A issue, but in reality, the board has said that filing errors are fatal. Right? 23A doesn't save a filing or service error.
Right.
It only saves essentially ministerial errors, which was what it was trying to correct. So I can't disagree with the board on the scope of 23A. And I can't disagree with the board's ruling here either, to be honest with you. And the appellate division throws out, I mean, I don't know. Is this result determinative justice? I think so. I think, yeah.
All right, moving on to the Peralta case. There were a lot of it.
Can I just interrupt and say, every time I hear this case, I think of Peralta from the 9-9.
I don't even know what that is.
He's like the main character in a comedy police drama, Brooklyn Nine-Nine. Yeah. And so I think of Peralta, and I'm like, it makes me feel less bad about the decision because I like him, so I don't mind him getting money potentially. But in this case, the claimant got screwed because the attorney got fees.
This is a frustrating claim or case because what happened here was basically the employer voluntarily paid the claimant his wages for the initial period of disability. At the first hearing, the awards were then formalized, reimbursed employer, and claimant's counsel requested a fee on those initial awards. However, you would take the position frequently that like that's a period that's already been paid, it's reimbursed employer. That's not something that the claimant's lawyer should be able to take a fee on, because if you look at the statute 24.2b, it states that where an award is made that increases the amount of compensation awarded paid for a previous period, yada yada yada, then the fee shall be 15% of the increased compensation. And there's really no increase in compensation when you were already paid for that period. We're just formalizing it.
Unless you are a hyper-technical appellate division judge who is doing a law school exercise and reading a single disjunctive as a double disjunctive, which is literally what happened in this case.
That's what happened here.
And it is this is not consistent with other rulings that they've made on the very same language.
Right.
So this is a problem. It does not reverse or otherwise affect all of that excellent case law that NYSIF created about the source of the funding, right? Because if money is moving to the claimant, the fee should be taken out of the claimant's money moving first until it reduces to zero, and only then is the funding source the employer reimbursement.
Right.
But seriously, how can you create rulings if you're going to be and there are several instances of outcome determined justice in our rulings.
Right.
If you think that way occasionally, why would you want to render a ruling that disincentivizes voluntary payment of benefits from an employer to an injured worker? Because that's what this does.
It's contrary to the whole basis for basically. It's like they want there to be voluntary payments by the employer.
The statute encourages voluntary payments. I think if the statute could come alive and have its way, it would tell you we want all employers to voluntarily continue paying wages to injured workers for some period of time until the comp system can establish what's going on in the case and set the correct awards. If that's the system you want to have, you cannot issue rulings like Peralta.
Right. It discourages it.
Right. Let's move on.
There's sort of just like a grab bag of more attorney's fees.
So the IWB, the plaintiff's bar, paid a lot of money, got the law passed to change fees, right? They get more fees now. They got their fees set. They don't have to do as much work for them. There's more predictability in what their fees are. And so what was predictable is the bits and pieces of it that didn't pan out the way they wanted, or that they had intentionally left on the table because the politicians didn't understand what they were being sold. They've now set to work. And they've set to work in a series of cases designed, with one exception. There was a case about successor attorneys. Pandolfi is clearly trying to fix a hole in the statute, but everything else is just them setting to work, expanding the locations and their opportunities to obtain fees.
Right.
That's all it is. And this will continue. And they will continue to challenge it. There were multiple challenges in the same areas. There were challenges on penalties. There were multiple challenges on the employer reimbursement. If you go back and look at the underlying board panel rulings on these topics, you will see an even more vigorous and concerted and organized attack on particular statutory provisions and particular language. It appears from what our review is that some of these must just be stock arguments that are being circulated among the claimants bar. And, they've got this language sitting. And so when they encounter the circumstance that they want to challenge, they have essentially most of a brief ready to go where they just fire off that appeal and challenge the board, because the board originally came down on our side on this.
Right.
And in fact, I remember speaking with representatives of the board. They're no longer there now, but at the time that this law had been passed, and the comment that was made to me was about this particular topic is, you will note that the statute does not provide for fees to be awarded against employer reimbursement, because this is meant to be an exclusive or an inclusive list, not an exclusive one. It was meant to be, you only get fees in these circumstances, right, but they're clear and broad, and there's more money going to move for the attorneys. I'd also note that the Appellate Division has said again and again, and it might actually be helpful to us, is that when these cases are filed, they're supposed to be rightly filed in the name of the firm. I didn't know if you knew that. There's a couple of footnotes where it's like, if it has nothing to do with the case, but it's only has to do with the fee awarded, it's not brought by the claimant.
I guess I have seen some where they did do that properly. Yeah, that makes sense. All right, so moving on to causal relationship and the Gunnis case. This is interesting for a couple of reasons, which first and foremost, and this is something we reiterate here all the time, which is that you don't need an IME to refute causal relationship. Causal relationship's the claimant's burden. And here the claimant was not credible. It's basically the best way, is the nicest way I can put it while on live TV.
Horse hockey.
Yeah, exactly. So in this case, he relied on, it was actually, I believe, the opinion of a podiatrist, which you run into problems there too, because they can only comment on the feet.
I think Brian just texted me, podiatrists are not doctors.
Correct. Yeah.
That's not true. They are doctors, but
to get this claim amended for the neck, back, and left knee. And what the board did here and the court affirmed was they actually went through the medical and found that this medical was not credible and didn't meet the burden of proof, because basically it was based on a podiatrist for the neck, back, and left knee,
right,
and subjective evidence. The claimant stated that, he had pain and that beforehand he didn't. And that's all it was based on.
If the claimant is tainted,
right,
their medical is tainted, that just because the claimant's nonsense, well, that's the word I'm going to use. If the claimant's malarkey is not sanitized by its recitation to and parroting by a physician,
right,
especially if that physician just claims ignorance, like they got it all from the claimant. And we want to remind everyone out there, because this is one of those moments where it's like you can think that the world is dark and grim, and it does feel like we're on a trek into Mordor to throw the ring into the volcano sometimes. But Hill v. ShopRite Supermarkets from 2016 is a template for the good defense of a claim. Hill even had an IME that gave causal relationship, but the board and the appellate division agreed that just because the doctors say that there's a causal relationship between an injury that they observe and the claimant's story doesn't mean that that's a real link.
Right. It's only as good as the history provided. That's
right.
Something that's cited all the time.
Hill is a disallowed claim on unanimous medical evidence of causal relationship. That is exactly what it is. And never forget that that can happen. So don't give up. Just make a plan. And remember, write a good cover letter. If you decide to get an IME, please do not just check boxes, especially in controverted claims. If you're sending out a checkbox IME on a controverted claim, you are just begging to get back garbage.
Another thing I think this is a good example of, which we'll see later in the fraud section, is this is an example of when you have suspicions about a claimant, which, as claims professionals, we all do sometimes with certain cases just from experience. It's good to dig a little deeper into it, because you might find, like in this case, that it's not credible. It's not a credible claim, and your suspicions were correct.
Isn't that a song from a Disney movie? Dig a little deeper.
I don't know.
I think I had to watch that. I think it's the one with Tiana in it. Ainsley liked that one. I had to watch it 70 times.
70 times, that's why you know it.
I know it real well. All right.
So next up, we have another COVID claim.
Let's talk about COVID.
So James is going to get into the really interesting COVID stuff. This is more your run-of-the-mill COVID, what we deal with now with the prevalence standard. But here the prevalence wasn't found, and neither was direct exposure. So this claim was disallowed.
Well, it's interesting because we picked it because it was reversed.
Right. That's
what's interesting about
it.
As everyone below said, it was a prevalence case. The third department said, come on.
Yeah. Basically, he was, I believe,
he was a janitor.
Maintenance worker.
He was a maintenance worker at a
school. And it's like, oh, well, he occasionally passed students in the hall. That's it. And I believe he was even the maintenance worker during the post school hours period.
Yeah.
Maybe there's some clubs going on.
Yeah. I mean, when I take my daughters to Girl Scouts or whatever, you're going into a school building after hours. They're working to clean up the mess. Right. It is a terrible job, but if passing somebody, and in this case, there were bad facts for this claimant too, is he did a whole bunch of other stuff that obviously would have exposed him to more people than his work activity.
Right. He went to church. He was very active at church, shopping.
I got the impression that this was a case of a person who poo-pooed COVID, but then was trying to freely avail himself of lots of benefits of the comps. You know what I mean?
Yeah.
I thought I sort of sensed that when I was reading it.
It's the right result, because if you think about, wasn't most of the science on COVID that you would want an exposure for 15 minutes or something like that? I don't know. I'm not a doctor.
Yeah, we're just lawyers. All right, let's move on. And we had some COVID cases at the Court of Appeals. Everyone was hoping it would be a big splash. I was hoping it would be a big splash. I even left the office to specifically sit and watch the oral arguments live. And I'm just going to say about angst is that there was a moment where we almost had it. The questions from the justices of the court were pointing toward their reticence to accept the prevalence standard because they were asking questions about when it ended, right? If you look at statistical data, I just heard this on NPR, according to statistical data, the death rate from COVID just dropped from being one of the top 2 to the top 3 causes of death in the United States. So certain data could suggest that we're still experiencing prevalence.
Right.
And the court was asking questions like, when do we stop applying this? Do we stop applying this when the politicians tell us it's over? Because if that's the case, prevalence never happened in Florida, right? And a whole bunch of other states, but prevalence lasted for a lot longer in New York.
Right.
And they were asking questions about that. What data do we use to decide when it's over or when it even started? Because they're still sussing out when COVID potentially came to the United States. So unfortunately, that opportunity was missed. There was a lot of case law discussion about the Wolf case. All you really need to know is that Onks tells us that prevalence is okay, even though it really doesn't live anywhere in the statute, except maybe a real gymnastic argument coming from section 21.1. I mean, even
and they cited some of their prior cases on these type of claims. You know what I mean? Like what I can't think of like a sickness that's comparable, but they were citing.
Well, we're gonna have more of them.
Yes.
Considering some of the vaccine epidemics that are coming up, we're going to start seeing that. And then McLaurin is just is a reversal because there's a disallowance from the board on a COVID stress claim. It's not actually COVID, but COVID stress.
Working during the pandemic.
The third department has a wild hair and says, "Nah, this is a stress claim," and the third department says no. And McLaurin really argues it turns on the second part of a phrase. Is it stress to similarly situated workers during a pandemic, or similarly situated workers, period? During a pandemic, the case should be disallowed. Period. The case should be established because, as the dissent said, like the COVID pandemic was an extraordinary circumstance, and even though this was decided before the statute was changed about PTSD and certain other stress, there is language in certain older cases that discuss stress-only claims that says that extraordinary circumstances can give rise to the development of a mental-only injury, right. And they said everything's extraordinary. So I don't know. I'm just still sort of. We had our moment in the sun where Ongst could have come back saying that none of this made any sense. I get the impression that, again, this is outcome determinative justice. The board had done this on thousands of claims. If Ongst reverses and finds that the statute or that the board's prevalence standard doesn't find any support in its statutory authority, there's a nightmare.
Yeah.
All right.
So the last COVID claim, which we can talk about really quickly, and we just basically put it in there because it's funny. Aside from prevalence, the other way, which is where I think everyone's fine with, you can demonstrate compensable COVID is through direct exposure. In this case, the employee was directly exposed to COVID by Rambo. that was his coworker's name. He proved that basically Rambo tested positive for COVID around the time that they fist pumped in the elevator.
They did.
And then they changed in the same locker room, and there were, supporting facts that this claimant was relatively COVID conscious outside of work. But the funny thing about this one is that Rambo gave him COVID. Rambo gave him COVID.
Yeah, I picked this case because I wanted to say to you all, Rambo always gets his man. Let's move on to Brady. We want to talk about Brady a little bit because this is a phrase that you may not have heard before, even if you've been practicing comp for a long time. The claim abated. So what we have is a claim for an injury filed during the claimant's lifetime. The claimant dies. But the claimant dies during the process of adjudication before the claimant can be cross-examined and before the claimant can be examined by an IME. So what we have is a record with some medical in favor of the claimant who cannot testify on his own behalf and who cannot be cross-examined and cannot be subjected to an IME. The board issues this really interesting decision, which is obviously appealed by claimant's estate. The board says, we choose to find that this case is abated because even though there's a prima facie for additional body sites in this case, we're not going to allow the case to be continued for further litigation because the employer has no meaningful opportunity to defend this file or develop the record. Abatement is not an often invoked theory, and the way that the board wrote this, they wrote this in such a way so that they could provide themselves pretty broad discretion, and the Appellate Division was kind of okay with that, which concerned me a little bit, to decide whether something's abated versus proceeding. They made it very clear that the board could just as easily have said, we're going to proceed. But this is the board and the Appellate Division deciding that certain things are due process, which I find interesting, and I want to make an aside here. They said that cross-examining the claimant was due process. The IME is due process. And so I think that that's important for our side of the table. I also want to suggest anyone out there who's interested in testing the theory of abatement on asbestos death claims that could have been filed during the claimant's lifetime but intentionally were not, which is a very common tactic for those firms where they've been suing in tort for years while the claimant was alive, but they intentionally wait to file the comp claim until later, like last. I would encourage you to try and take this up and try and test the bounds of this theory of law.
Could be a good site.
Yep.
All right. So next up we have stabile, which is another death claim involving a heart attack. Claimant was found unresponsive in the employee parking lot after he left work. This claim was disallowed below and disallowed again on appeal, or affirmed on appeal. And the reason being is that here basically there was plenty of medical evidence to show that he had pre-existing conditions, which rendered him prone to this type of thing. And then there was no evidence of any sort of work-related stress that would have precipitated the heart attack. So basically, I mean, it was disallowed under a theory that the accident didn't occur in the course of the claimant's employment. And this is a good result. I mean, it's the proper result.
Yeah, this is the correct result. I'm glad that there was effort taken to defend this file, because so many people see unwitnessed cardiac event cases being established. It is true that if you do not put up any fight, the case will be established, even only on a death certificate. There's case law that says that. All right, let's move on to tricky. Tricky. One of my other favorite shows has a character named Tricky Woo in it, but that's a dog. I picked this case because I'm gonna toot Lomad's horn a little bit and say, when the Construction Industry Fair Play Act came out, everyone looked at it and groaned, but Lomad was one of the first firms to come out and give a training on it to explain what it really meant and to really simplify it. And that was a long time ago. Now we see it in play. The only things that are interesting about this case are that we're in the opposite situation that you would expect. The employer wants the claimant to be an employee, and because they want the protections of Section 11 and exclusivity, because the claimant has a potentially very valuable tort action against against Black River Plumbing. And while it suggests that the claimant may be an independent contractor, so far they haven't been able to prove it. And Brendan's comment on this, I think, is the correct one. If you're in the Construction Act, you can just basically assume that absent something really extraordinary being present, you will be an employee.
Even if you want to be found, not an employee.
If you want to be found, it's going to be hard for you to make it. Literally, there's a 12-point test and an ABC test. It brought me back to law school days, and I thought it was way overcomplicated the way it was written, but let's just.
I'll just say, not to brag, I actually did get a claimant found to be an independent contractor under this years ago.
Oh, I remember that. That was the
I don't know how.
That was the uninsured employer case, right?
I don't remember.
Was that the one where the sister was filed a claim against her sister's business? No, okay.
No, this was just a random one-off, but still.
Okay, it happens, yeah, but it's hard.
All right, so extreme hardship. There were a lot of extreme hardship cases this year. I mean, there's usually a handful, I would say. This one, James and I were talking about it beforehand. It's kind of interesting in that it's an extreme hardship case. That's sort of the dressing they put on it, but they're really just trying to find a TID, temporary, or a total industrial disability. And what happened here is, when you're trying to prove extreme hardship, they go through basically your assets, your expenses, and there's even the note that simply having a shortfall won't be automatic proof of extreme hardship, right? Because there's a lot of cases where like the boat payment is making it so you have a shortfall, but you don't need the boat payment.
Right.
Here, the way that they decided that there was extreme hardship is they really relied on the other relevant factors component of considering extreme hardship and said, well, this claimant recently was diagnosed with cancer. This claimant had COVID twice in the recent past.
75 years old too.
And is 75 years old. So they're probably not going to be able to make the money they need to make up this like $200 shortfall. Right?
But that's really not the analysis, though, that it's used in any other case, whether they can make up the money. That they never get to that step. But they talk about it in this case. And I agree. We both readily agreed once I said this is just a TID case that's wrapped up in a Section 35 analysis. So maybe that's what the board wants to have happen, is that like TID is not its own issue anymore. They're just supposed to bring this up and they'll consider 35 Section 35 claims in a TID framework.
Right.
I just don't like it.
It's not fair because you should be able to litigate TID.
Right. I mean, why do we care about, and the other thing is too, is that it's been long held, and Melissa has repeated to everyone at this firm since the day of its founding, the board doesn't have the right to award benefits for anything that's not a comp-related condition.
Right. Which is essentially what's
But this is LWEC creep. This is LWEC creep.
Mm-hmm.
It started with the loss of wage earning capacity, other factors, but there's even case law for LWEC that says, listen, unrelated comorbid conditions really aren't supposed to go into increasing your LWEC. We're just supposed to pay for what we did. But there's also the contrary argument that you take your claimant as you find them, which is what they're really leaning heavily into now.
And I think what you'll see when you read all the extreme hardship cases in any given year is they apply different standards. So here, you know, in other cases, you'll see them really go through like the car payment. They'll be like, well, what kind of car is it?
Right.
Or, you know, that type of thing. The cell phone, what kind of cell phone is it? They actually go through those things. Credit card debt, they'll look at the type of credit card debt.
We may not get to it because it's later on, but I want to add there was another extreme hardship decision issued at about the same time as this one, where it was very clear that they hated the claimant because he testified that he was an old white man and that his $800 a week food bill was a result of the fact that he was raised during a time, I can't remember how they put it, where it was expected that women cooked food.
That was a quote from the claimant.
Yeah, and that he was too old to learn.
Yeah.
And so he had to buy pre-prepared food. So it was basic, and they made a point of putting that in the decision, which tells me from reading these for so long that really changed the way they thought about the case.
Yeah.
All right, let's move on to fraud. We need to talk about something sexy for a minute.
Yeah.
We're going to talk about fraud cases. And we don't just talk about fraud cases because we want to tell you about fun facts and cases. We selected the cases because this is how lawyers learn. Hopefully, that's how we learn here.
Right.
Is by contrast. Alzadi and Ogon are contrasts. Both have to do with priors. Both have to do with claimants concealing priors. The difference between these two cases, one is no fraud, one is fraud plus lifetime. Alzadi's fraud plus lifetime. What's the difference? The difference was the development of the priors and the nature and extent of the original hook that was used to develop the fraud defense. In Algon, the claimant had one ER visit 4 years earlier, which the claimant alleged that they forgot about, right? And that had resulted in them needing to get a neck MRI at the time. But there was no other treatment, all right? Algon is not fraud. They pursued that case. It was questionable when I think it was questionable to be brought up in the first place. There was potential for fraud depending on what judge they got into, but it was never a great fraud finding. Certainly it doesn't seem like it was something that would warrant going to the third department. Alzadi, on the other hand, the claimant says, I can't remember my priors, but there were extensive priors, multiple pages of records, multiple visits, and 2 prior accidents, a slip and fall and an MVA. So here's the difference.
You're telling me you didn't remember that?
You're telling me you didn't remember that. Both cases, they claim faulty memory. One is no fraud finding, one is a fraud finding. The decision is, the result could be traced back to the decision made about which one to pursue and when, and the extent of development of the record that was going to occur before the trap was sprung. Alzadi also had a few more lies in it. They lied to the IME and the C3. The claimant just said, I don't remember.
Yeah.
In testimony.
I think Ogon too, like, it's a good example of, obviously there's got to be a cutoff point. You can't just indefinitely spend money, but having some patience and actually trying to dig a little deeper can go a long way, because I actually think they were onto something there, because the court sort of glossed over the fact that there was a pre-date of accident neck MRI, which sort of triggered their discovery of the ER report. And like, I mean, we all know like MRIs aren't ordered for no reason.
Right.
So there might have been something.
And you usually don't get them at the ER. The point being is that one was developed more fully than the other.
Yeah.
And maybe Algon could have been a different result had they pulled the trigger 6 months later.
Yeah.
But you have to be persistent. Let's move on to Debrin.
This one's funny.
This one's funny. This claimant is deemed permanently totally disabled, which really shouldn't happen all that often. and is caught on video bidding and providing an estimate for a residential home improvement project. Okay, so
in a shirt with his company's name on it, which was his name.
Right. You know the monkey, see no evil, right? That's what I think I see the board. No. They got their fingers in their ears, their eyes closed. We don't hear you. We don't hear you. He didn't actually swing a hammer, but he bid the job. And the board says estimating the job isn't work. In my experience, there are companies out there who literally employ people whose only job is that of an estimator.
Because it's extremely important to their business.
It is incredibly important to their business. In fact, there are courses you can take to become a better estimator for stuff like this. Right. So that the board says that this is not work is ridiculous. Mm-hmm. And that the board defines what it thinks actual work is ironic. And we're just going to pause for a moment of silence to the death of work, right? Because lots of stuff that we do every day apparently isn't work.
I know. I find it funny. It's like, so to the board is work just like only swinging a hammer or something like that?
Well, I mean, if you read the statute, it's still written in the masculine and was still written with so many provisions designed to reflect essentially a unionized or otherwise organized workforce working in like a steel mill in 1927.
Right.
So if that's the way they think about work, maybe they don't work either.
All right, I think this is the last fraud claim. Tirado. This is just a really good example of something that is important to know when you're dealing with fraud, which is that you get the surveillance, it shows evidence of fraud, you got to follow up with an IME addendum. Okay. So in this case, the claimant was found on surveillance to only be using a cane while attending IMEs, but not before or after the examinations. That's some of the best fraud evidence you can ever get. I think we've all had that here, and you're sort of giddy when you get it because it's just so obvious. But they did the right thing here, and they sent that surveillance to the IME doctors. Both IME doctors issued addendums, and on review of the materials, stated that the claimant displayed physical and mental capabilities in excess of what he portrayed on exam. Boom, fraud. So you need to couple your good surveillance with an IME addendum, and sometimes you'll even get an IME, a potential fraud claim, and you'll have surveillance going on at the time, and the IME will find no causal-related disability. It's still good practice to send that surveillance evidence to the IME, even if they're only going to say, yeah, it's consistent with what I observed, because I'm assuming in that type of case, the claimant's medical is very different. It's saying that they're much more disabled than the IME observed. So it's important to get that.
This is also a case that illustrates the point that if you are careful and patient and thoughtful about how you tee up a comp claim, all you can do is improve your chances of success.
Right.
Do not rush off the start line because it's a race that you get to start yourself. Let's move on to Troiano. We want to talk about this case because we want to point out that the Appellate Division takes seriously the board scheduling orders. The facts of this case are very simple. An SLU opinion comes into the file. The board issues an ECU 81.7 scheduling order directing the parties to do something about it. We all know about those. We discussed those in detail last year. We discussed them in circulars and white papers. And in this case, unfortunately, New York City Housing Authority didn't do anything about it. And then the board issued a ruling awarding the higher schedule, and they appealed it, and for the first time on appeal argued that the treating physician's report was an IME and should be precluded. The board bought that and retroactively precluded it. On appeal to the third department, the claimant says 137 may necessarily preclude this, but there's a long line of cases saying that it has to be raised timely. And because it was raised for the first time on an appeal, not at any time during the 75 days granted by the scheduling order for the employer to do anything, the issue was untimely, and therefore it was improper for the board to address it. The Appellate Division agrees. What is interesting is that the board has 123 jurisdiction, and the Appellate Division has lovingly cultivated 123 jurisdiction anytime it agrees with the result that the board came to, or especially in all those line of cases about post-classification nonsense about temporary partials in the Jacoby era, why the board is somehow, that has de novo jurisdiction, restricted from considering that issue is one thing. But this was also remitted. Bear in mind, it was remitted, and we haven't seen the result yet.
Right.
The board could come back and say that they believe that the scheduling order, because the scheduling order doesn't provide an opportunity, there's no requirement that the carrier actually like write a letter seeking preclusion.
Typically, you'd raise it at the first hearing.
Right. They could say first hearing, and there's case law to support that. So the reversal here is only to the extent that the board didn't really address the issue of timeliness.
Right. All right. Moving on to Piover. That's how I'm going to pronounce it. Labor market attachment case.
Jover. That's a Megan pronunciation.
So this is just a really good example of not taking C-258s at face value. You see it all the time. This will just flood the file with job search records, okay? And maybe they're even legitimate. With Indeed nowadays, it's pretty easy to mass apply to jobs to try and get your labor market attachment proof satisfied.
You could even write like crawler script to do it for you. You wouldn't even have to do it yourself.
You really could. Yeah. So a lot of times you'll see, or you'll go to a hearing and they'll be like, okay, you're accepting labor market attachment, right? And the answer is not always yes, and it shouldn't always be yes. You should go through those job search records because you'll see quite often applications, or like all of the applications, will be for work that the claimant's not capable of doing or that it's not within the restrictions. What I like about this case is this is actually more based on the fact that the claimant just can't do this work, but not related to his injuries. It required English proficiency, which the claimant didn't have. Now you will find case law where like, okay, he's taking ESL classes. That could help find
almost certainly will,
and that's fine.
Yeah.
And then here, required specializations or education far beyond his background. For example, optometrist, paralegal, social worker, Bengali-speaking marketing specialist.
Workers' compensation law judge.
Yeah. So yeah, these are all very technical positions that require, certain degrees and whatnot, none of which he had. And a lot of times, I think this is a good case for us because a lot of times the board will kind of constrain what they consider to whether the claimant applied for work within their restrictions and kind of turn a blind eye to whether they actually could realistically get the job.
Right. This was ridiculous facts. But we have to contrast this against last year's decision where the claimant threw up, like, what was it, 300 or 400 crappy job applications.
Right.
And the third department was like, well, quantity is enough here. And the dissent in that case actually said, this is trash.
That's not how it
works.
So
this might be the Appellate Division sort of saying, okay, this isn't about quantity, it's about quality. We're running short on time, and we have a lot of other cases, but I want to talk about one that's really important. We're going to skip ahead to Junkel. Sorry, Justice, you're going to have to find that one. Junkel has, we're going to find it. You'll just have to bear with us. Don't look at the screen. Junkel is a case about retroactive suspension of benefits or the timing of suspension of benefits that are on a CCP. We all know that 300.23b says that we can suspend benefits unilaterally under certain circumstances, like, for example, proof of death of the claimant, incarceration for a felony, or, for example, a release to work full duty by the claimant's own treating physician, etc. But it also says that benefits on a CCP shall continue until further decision by the board. There's also another regulation that says that the board is supposed to schedule and hold a hearing within 20 days of an RFA2. So there's been a bunch of case law that's developed over the years because we all know that it's really unfair to carriers and employers where CCPs, for example, at total, are brought to the date of the hearing at total, even though there might be 2-month-old medical evidence that says that the claimant was partial. That's a taking. That's just a flat-out taking. You're paying the claimant 2 months at total when their own doctor said 50.
Right.
So there was a line of cases that basically said the board had been developing it that they would retroactively reduce or suspend based on the date of the RFA filing, or perhaps the 20 days after the RFA filing when the hearing should have been handled or held but wasn't. but they were giving us leeway. Now Junkel says, tough. You got to wait for the board. You got to wait for the hearing. And they base it on the fact that the board interpreted its own regulation requiring them to schedule a hearing within 20 days as aspirational. Now, some of you out there may be lawyers, some of you aren't lawyers, but I can tell you when I was in law school and I was taking administrative law, and when I took courses that discussed how lawyers are supposed to read regulations and read statutes, nowhere do I remember anyone ever describing to me the concept of an aspirational regulation.
I don't either.
A regulation is supposed to constrain the conduct of a governmental entity or a private citizen or a private entity. They are not aspirational. Aspirational things are like done by acclamation, by statute, and are not enacted by agencies.
Or it'd be written in. It'd be like, will attempt, shall attempt to, or something like that.
Yes,
You
like
know?
there's no point in
not
creating
written.
such a regulation.
No.
That's the sort of world. Aspirational regulations are for dictatorships that don't want to follow rules when they don't want to follow rules.
Right.
So I have a problem with this. I hope you all out there have a problem with this. This is one of the ways that the system could have been made much better for business.
For sure.
To use the board's own words, it could have been better for business by the board saying, we don't have authority to make an award at total if the claimant's medical is less. By the way, we have all this case law for years where we've said that CCPs are all tentative in rate and subject to modification, and we have 123 jurisdiction, and they could have created case law that said, yes, we're supposed to hold the hearing and issue a ruling, but the timing of the date that we make the ruling is not the timing that we have to make the award.
Right.
We don't have to match the award to the date of the hearing. That is the kind of thought process that I understood lawyers were supposed to undertake.
Mm-hmm.
It's like, okay, just because we're having the hearing now doesn't mean that now is the same date that has to be on everything that we make. Retroactivity applies in workers' comp in so many different areas, apportionment being one.
Right, but not here.
But apparently not here. So what's going to continue happening for the immediate future is that claimants are going to get CCPs brought to date. The judges love this because it means they don't have to do any thinking.
Yeah, it's easy for them.
And I want to add, we just have a couple minutes left. I want to add that you all may be aware that the board has proposed regulations sitting out right now, changing the way, the manner and method and conduct with which litigation depositions are going to be scheduled and paid for. They are not good. They're going to lead to extensive additional litigation. It is going to cost all of us money, even if we don't have to appeal, and we expect we will have to appeal extensive and multiple denials of the right to cross-examine a physician, which we are almost certain we're going to have to do. The new regulations require the employer and carrier to bear the costs of scheduling the depositions, which means you're going to have to pay to arrange the deposition and to subpoena the doctor and provide the court reporter and produce the transcripts for every doctor, including our IMEs. And we are going to have to appeal all of those cases where we request cross-examination of a particular physician and that cross-examination is denied because the judge mistakes burdens of proof, because the claimants, as Hill v. Shoprite tells us, always got the burden in the first instance. We have been told that this should be fair for us because the judges are going to be trained and instructed to insist that a claimant's lawyer identify the physicians who support their contention for whatever benefit they are seeking. I have very little faith that that is going to become commonplace. And so now is the time to make your concerns known. And if you have the inclination and opportunity, we have some bullet points prepared that we can provide to you by email so that you could perhaps put them into your own words or express them in your own particular manner and send those to the board's email, which has been set up specifically for receiving comments on this particular change. It seems to me like it was a concession to the claimants bar and perhaps some whiny judges who anecdotally said that they were getting more deposition requests than they thought were appropriate. I think what it actually was that judges didn't like losing the discretion to do whatever they wanted.
Right.
And then we're receiving records that, as our our fearless leader pointed out, most of the cases where we're requesting testimony without contrary medical is because the claimant's medical evidence of a total disability is just garbage on its face.
Right.
And this is actually trying to punish employers instead of training doctors, or telling judges, yeah, maybe it's okay for you to infer that a claimant is not totally disabled from a pinky injury.
Right.
Right. But judges really don't want to do that. So unfortunately, we're in this tough spot, and now's the opportunity to affect some kind of positive change, perhaps even if it's to getting them to amend some of the language of this to make it clear that perhaps a judge doesn't have discretion under certain circumstances, or to force them to add that first requirement to the regulation that a judge is required when testimony, like when an application for benefits is made, the judge is required to identify the physicians who provide the medical evidence or support which is offered in basis of the request. And those cross-examination of those physicians shall be granted.
Right.
At least force them to do that. That would be an easy fix. That might avoid 60% of the appeals that are going to be generated from this. It's also likely going to be challenged by due process, because denying cross-examination of a witness that could be used to award benefits against you is probably a denial of due process, sort of day one law school kind of stuff. But this is important, so get out, be active. Thank you. I guess we'll open it to questions. It's 1 o'clock. I know maybe your lunch hour is over, but are there any questions in the chat? You can put your questions into the chat. While you're doing that, we just want to remind you that if you want more great content like this case law update, please consider becoming a LOMAD VIP. That gives you access to LOMAD TV and our magazine. It puts you on the mailing list. You get updates from us, which are frequent. They help you stay abreast of what's going on. They help you stay in touch with what the industry is doing, and they help you do your job, to be quite honest. We use them internally. So without anything more, we'll open it up to questions. Anything? Nothing?
We're too thorough.
We'll think that.
Yes.
I choose to think that. Well, on behalf of myself and Brendan and everyone here at LOMAD, I want to say thank you for joining us. And if you do want a copy of our bound presentation for the year, of our paper presentation, it's actually digital now. I say paper, but it's just because I'm probably getting old. We'll be able to provide that to you in PDF format that's going to be indexed and searchable. It's lovely. It was just like last year's. That should be available early next week. Send an email to mail@thelomad.com, and you'll be provided with a copy of the update for your desk, a handy desk reference.
Perfect.
Thanks, everyone.